So that's the power under D. With consent, with concurrence. Take fundamental rights. That's nothing to do with the lists, Manoj. So 371, B1 and 2 talks of the lists. By law, particular lists. Instrument of accession, only those 4 items. That's B1. B2, other lists. That only refers to lists. That's 370. Then you come to Mallards, the application of constitutional orders to Jammu and Kashmir. Now, where any law passed under the lists, if it relates to Mallards, instrument of accession, consultation. If it relates to other things, concurrence. But substantive provisions of the Constitution were made applicable, Mallards. That also with concurrence. And this was being done between 1951 and 1957, when the Constitution came into force. Then the Constitution took over.
This was between 1951 and 1957.
After that also there were application orders. Because 371D, Mallards, continued in operation. So that's why I want to show you the 1954 constitutional order, which superseded the 1950 order. And it will show Mallards what was done. So nothing was ever done without concurrence, except Mallards for those 4 items. Never. Till date. So now kindly see page 13. PDF 13, volume 3. Documents, Mallards. Volume 3, PDF 13.
Page number?
Page 13, Mallards. PDF page 13. Running page 406. Mallards.
14th May notification?
Yes, yes. Now, kindly see, Mallards, by this time the Constitution is not in place. But they have superseded the 1950 order. So all orders hereafter were with respect to 1954 constitutional order. Because 1950 was superseded by 1954. So every other order was under 54. Now let me just show that to your lordships. The following order made by the President is published for general information. The Constitution.
Just 1 second. I just need only 1 minute to
I'm sorry.
get back.
I'm sorry.
I was focusing on something in the Constitution. Which volume would you?
Volume, documents, volume 3, PDF page 13.
Yes.
Says the Constitution application to Jammu Kashmir Order 1954 in exercise of the powers conferred by Clause 1 of Article 370 of the Constitution, the President, with the concurrence of the government of the state of Jammu and Kashmir, is pleased to make the following order. The order may be called the Constitution Application to Jammu Kashmir Order 1954. It shall come into force on the 14th of May 1954 and shall thereupon supersede the Constitution Application to Jammu Kashmir Order 1950. Now see what happens thereafter. The provisions of the Constitution, which in addition to Article 1 and Article 370, because that's Clause C, Mallards, shall apply in relation to the state of Jammu and Kashmir and the exceptions and modifications subject to which they shall apply shall be as follows. Now, preamble. That's the power under D. In with concurrence. So, Malas, you see part 1 to Article 3, there shall be added the following further proviso. Provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of that state. Now, this is passed by the constitutional order applicable to Jammu and Kashmir. That's the solemn promise, Malad, that has been made, that you will not change the boundaries. And that's with concurrence. And that's exactly what they did, without concurrence.
Mr. Sibal, why is it that, what is the distinction between the consultation with the government of the state, which is referred to in the first proviso to D, and in clause 1 of B? Because clause 1 of B also refers to consultation with the government of the state, and the first proviso to D also refers to consultation with the government of the state. So it will be a surplusage. There has to be a meaning for why there's two separate provisions in relation to the same.
I must explain that. I must explain that. Because if you look at Muller's B1, it says make law. It's not in relation to the same thing. So it says make law with respect. So it only deals with the lists. If it comes to instrument of accession, those 4 items.
Actually, I was looking at it this way, possibly. I mean, just thinking aloud, maybe wrong, correct me if I'm wrong. B1 refers to the specification of matters,
yes,
on which are covered by the instrument of accession,
yes,
in respect of which Parliament can make laws. That is B1.
correct.
It refers only to the specification of matters in the union list, which are covered by the instrument of accession, on which Parliament would have the lawmaking authority. That is B1.
Absolutely.
Now, the first proviso to D would obviously not cover that category. Otherwise, there was no need to put the first proviso there.
Well, those only
Just see, just one second.
I'm sorry.
See, the first proviso also says, provided that no such order which relates to the matters specified in the instrument of accession of the state referred to in para 1 of subclause B shall be issued except in consultation with the government of the state. So the first proviso also refers to the matters covered in clause 1 of B. It also refers to consultation, and B1 also refers to consultation. Now, possibly the meaning which can be attributed to the proviso to D is this. D says, such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the president may make. So where the president is making an exception or modification to another provision of the constitution, then the president has been given the power. But what the proviso says is, the first proviso says is that if the president is making a modification or adaptation in respect of a matter which is referred to in clause 1 of B, namely something covered by the instrument of accession, then you require consultation. The second proviso then says that no such order which relates to matters other than those referred to in the last paragraph will be made except with the concurrence. I was wondering, just thinking aloud, what D says is that if the president is making an exception or modification in the application of any provision of the constitution to the state of Jammu and Kashmir, then you require either a consultation, first proviso, or a concurrence in terms of the second proviso, right? Now, what happens if the president is not making any exception or modification at all? Does that require either a consultation or a concurrence?
Yes, Manas, according to me, yes, but let me explain.
Because this adaptation order which you showed us, for instance, of 1954 makes modifications. Preamble will apply subject to these exceptions. Directive principles will apply subject to these exceptions. But what happens if the president is not making any exception or modification at all? Then do you require a consultation or modification in terms of clause D?
May I, Malas, then?
Yes.
On Malas, since you're
Yes.
Now, Malas, kindly look at B1 first for a minute. It says the power of parliament to make laws for the said state shall be limited to matters in the union list and in the concurrent list. It doesn't say anything more than that. It specifies the lists under which they can make laws.
Which?
Again, no, that's right. They are not, the law has not yet been made. It's only the
Are
power.
declared by the instrument of accession.
Correct. So, Manoj, only the list communication.
Right.
I'm not talking about, the law has not yet been made.
No, no.
So they are correlating the making of the law to the items in the lists. When it comes to the instrument of accession, it has those 4 items. When it comes to other matters, it is in the concurrent list, not in the state list. But they are not setting out, Manoj, what
Now,
law is to
one very important thing is that clause B does not confer the power upon parliament to enact law for the state of Jammu and Kashmir. It limits it in certain respects. The power of parliament to enact law is under 245 and 246.
246 will not apply.
No, but the power is somewhere else apart from B.
No, Manoj, I'll come.
B recognizes the power of parliament to enact a law because it says the power of parliament to make laws for the state shall be limited. It's a limitation.
No, it's a limitation.
But Justice Paul also says that it's a limiting clause.
Yes, square that list only means square that list.
So if it is a limiting clause, the power of parliament to enact the law is traceable elsewhere.
No, Manoj, now, Manoj,
Can we say that 370B gives power to parliament to enact law? No. It limits the power of parliament to enact law to a certain extent.
I was trying to explain what
Yes.
the Lord put to me. Please allow me.
Yes.
What I was trying to say was that here, what the clause says is that where the lists in the instrument of accession, right? Parliament may make a law, but that will be in consultation.
It's a double limitation, Mr. Sibal. See, the first limitation is the chief mentioned. Power of parliament to make laws for the state shall be limited to.
Yes.
What is it limited to? To matters in the union list
Yes.
and concurrent list. So first part is matters in union and concurrent.
Correct, correct.
But second qualification, which in consultation with the government of state, there also you are right, to that extent you are right, it is in consultation with government of state, are declared by president to correspond to matters specified in the instrument of accession.
Correct.
Governing the accession of the state.
Correct.
So such parts of union list and concurrent list, which form a part of the instrument of accession, because everything else doesn't form a part of the instrument of accession. The whole list doesn't.
Right.
To that extent, Parliament can enact law. Parliament is limited to enacting laws in respect thereof in consultation with the government.
Absolutely. Right.
That's
No,
how I
they got, that's what I'm saying too. But they are not, at that moment, the law is not made. They are only saying the contours under which Parliament will enact a law. The contours with respect to instrument of accession are those 4 items: communications, defense, external affairs, and ancillary, which I showed to your lordship the schedule. When it comes to B2, the contours again of the items in the concurrent list over Parliament may make laws. Again, it doesn't say that law is made. It only delineates the contours. Therefore, I'm going to now distinguish it from D, Manoj. That's how I'm going to.
Let's come to D. How would you?
I'm just coming.
Yeah.
Then you come to see the provisions of 1 and of this article shall apply in relation to that state. That's not covered. That's not covered.
Right.
So that's Manoj. 1 is integration into India. And Manoj, the other is Article 370. Now come to D. Such of the other provisions of this constitution. Now we are not talking about lists. Now we are not talking about lists. We're talking about preamble. We're talking about 356. We are talking about fundamental rights. Each of those orders require the concurrence of the state. I'll show that to your lordship. Here it is such of the other provisions of this constitution. 371B doesn't talk of any other provisions of this constitution. It talks of the instrument of accession and the concurrent list, the contours of the power. When you come to other provisions of the constitution, these may be made applicable. That's why the order. Now let's read it further. Such of the other provisions of this constitution shall apply in relation to the state, subject to such exceptions and modifications as the president may order set specify, not referred to 371B. There's no order, no question of order there. It's only the contour of the power. Now read, provided that no such order, that is no such order relating to D, which means provisions of the Constitution of India to apply to Jammu and Kashmir. No such order which relates to matters specified in the instrument of accession referred to in paragraph 1 of clause shall be issued. Kindly note the word issued. That's the difference between 371B and 371D. Because no orders are issued under 371B.
That's the power to make law.
That's only the contour of the power. Your Lordship asked me the difference between the two. I'm just trying to advance an argument with respect to the difference. It's entirely different.
Yes, much.
Yeah. Yes.
So, Attorney General, that two constitutional practice is one thing. We are now looking at just the text of the provision. There are two possible constructions of clause D. Constitutional practice may seem to support what Mr. Sibal is saying. One is that D refers to the fact that other provisions of the Constitution may apply such
Other than one and
one and two. Such of the other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. In other words, if you are making exceptions or modifications, that's one construction. That if the President is making exceptions or modifications, then if it relates to a B1 subject, then you require consultation with the state. If it relates to something other than a B1 subject, you require consultation of concurrence of the state. All right? So it is only where you are making exceptions or modifications in the Constitution that it requires either consultation or concurrence. The other interpretation is that even if you are not making any exception or modification, but you are making some provision of the Constitution applicable to the state of Jammu and Kashmir, you still require either consultation or concurrence, even if you are just bodily lifting it and making it applicable without exception or modification. That's the second construction of D.
That's correct.
Now, the question is really which is a more plausible construction?
I can do that. Because actually, if your lordship looks at the 1950 order itself, it will give an indication of what was meant. And just not leave 54.
That's why, Mr. Sibal, the Chief Justice said constitutional practice does support this view, but there are two plausible constructions which can be made. One is that the entire Constitution has been adopted in terms of clause D. If you require modification or changes in that part, then you require a presidential order which shall be issued in consultation, not in consultation, with concurrence of the state.
I appreciate that, but that will render three OCOs completely. C will become OCOs.
C is
the provisions of the
The
Constitution.
C is something different. C dilutes the article itself.
C, Madhur, I am not on anything else. When you see other provisions of the Constitution, except for one and the 370, you can't touch 370. But let's move forward, Madhur. I'll be able to show that to your lords.
P is 370 and C is Article 1.
And one is Madhur's integration.
Integration.
So that can't be touched. If part of India can't be touched. 370 can't be touched. All other things can be touched.
It doesn't say, C doesn't say it cannot be touched.
Interpretation.
C doesn't say 370 cannot be touched. In fact, clause 3 makes it very clear it can be touched. It doesn't say it's touched.
By now, your lordships have, in fact, Madhur, may I tell your lordship something interesting? Because I looked at the original Constitution of India. Learned friend will show it to your lordship. It was only a marginal note. It's not the heading of 370.
It's a marginal note, absolutely. No doubt about it. It's a marginal note.
It's a marginal note. And your lordships have held in Keshavanam Bharti itself. Can't look at these notes.
No, in the sense that a marginal note doesn't control the meaning of the text.
C and 3, Article 3. You can't. A marginal note can't say it is temporary, therefore I read this in this fashion. Can't be done. Anyway, come to that one. Let me Madhur, show you. It's
Yes,
very
yes,
fascinating.
yes.
But take a bit of time. Let's kindly come to 370 presidential order.
That 1954 order.
1950.
Let's have a look.
50. Same volumes.
1950 or 54?
No, Madhur, I'm coming to 50, Madhur. Liquid text. Volume 3, PDS page 4, Madhur.
This is what you were reading as 13. No,
No, that is the 54 order. I'm coming back to 1950 order, which was superseded by the 54 order.
This is where?
This is PDF 4 in the same volume. Madhur. The other was on at 13. This is at 4.
This is at 4.
Yeah.
Are you
Kindly
referring
see.
to CO number 10, Mr. Sibal?
Yes, absolutely. Well, let's kindly see the index of this. 3 pages earlier. Yes. See what has happened here. This will give you the kind of orders that have been passed from time to time. There are, by this time, about 54 orders. These are probably not all the orders either.
Very first page of the volume.
Yes, yes.
The first page of the volume.
That's right.
We are looking at
There's
the
a whole
different
index of all the orders.
orders issued.
Yes.
Serial number 1 was superseded by serial number 5.
Too specified.
Now read it with me. The order may be called the Constitution applicant to Jammu Kashmir Order 50, which should come into force for the purposes of subclause B1 of clause 1 of Article 370 of the Constitution. The matters specified in the first schedule to this order, being matters in the union list. This is in consultation. Kindly read the words. In exercise of the power of 370, in consultation with the government of the state. For the purposes of B1 of clause 1 of 370, the matters specified in the first schedule to this order, being matters in the union list, are hereby declared to correspond to matters specified in the instrument of accession, governing the accession of the state of Jammu Kashmir to the Dominion of India as the matter with regard to which the Dominion legislature may make laws for the state, and accordingly the power of Parliament to make laws for that state shall be limited to matters specified, which your lordship said is the limitation. Rightly said. Now come. In addition to the provisions of Article 1 and 370, again, of the Constitution, the only other provisions of the Constitution which shall apply in relation to the state of Jammu and Kashmir shall be those specified in the second schedule to this order, and shall so apply subject to the exceptions and modifications specified in the said schedule, and the modification of that all references to the said provisions shall be construed as reference to the Sadre. This is applicable to D. First schedule deals with entries, and this deals with D, because you're not to apply now the provisions of the Constitution of India. And they are all incorporated in the Constitution of India as applicable to Jammu and Kashmir order. So 356 also comes there, Part 3 comes there, Preamble comes there, Directive Principles of Policy come there, but that's all with concurrence. Therefore, it didn't come at this stage, that happened later. Then you went, then now kindly see the first schedule you have seen. These are those very entries that we were talking about. And kindly see the second schedule. It starts, at PDF 6, page 17. I just for my lord. PDF 6, page 17. Kindly see exceptions. Article 72(1), provisions of the Constitution applicable. So there was no doubt on this issue, entirety of Part 5. Part 5, 72(1)(c), 72(3), 133, 134. Those are exceptions. Last column is modification. So it's not just a question of application. It's a question of substantive understanding of what 370 is. Even if you want to apply a provision without modification, you need consultation with respect to or concurrence. You can't. There is no third way of doing it. Yeah, that's excluded anyway. I said that we've given the examples. Modifications 54 and 50 shall apply subject to modifications that the reference therein to the elected members of the Houses of Parliament to each elected member of either House of Parliament shall be deemed to include respectively a reference to the representatives of the state in those houses and to each such representative. So you modify 54 and 55. Then if 247 you modify. 246 shall apply subject to the provisions of paragraph 2 of this order, and clauses 2 and 3 of 246 shall not apply. So you can't pass a law.
So what is the effect of clause 2 and 3 of article 246 not applying in relation to the state?
Because the residuary power is with the state.
No, but 246(2) says, refers to the power of parliament and the state to enact laws on the concurrent list.
That's fine.
No, but if 2 is not applicable, then neither the state nor the parliament can enact a law on the concurrent list. then.
It is because of 1B, Malaz. It only tells you the methodology, Malaz, that's all. The point is, what my lord is putting to me is, the president can exercise powers under 370, dehors a modification. That's an exercise of plenary power. That's what my lord is putting to me. But Malaz, this clearly shows that even that exercise has to be done with concurrence. If it relates to the concurrent list and consultation if it relates to instrument of accession, can't be done any other way. So it's not a matter of practice alone, it's the substantive interpretation of 370. Kindly see the first column, Malaz. All the articles apply. Part 9, Part 11, Part 12, Part 15, Part 16, Part 17, Part 19, Part 20, everything applies. But in those parts, there are exceptions and there are modifications. That's set out in the third column. Nobody disputes that. The whole part applies.
Clause 3 of the order seems to suggest that the only provisions of the Indian Constitution which would apply to the state of Jammu and Kashmir are those which are specified in the second schedule, and that too with the modifications which were made.
Absolutely. That's our submission. And then this is superseded by the 1954 order. For example, Part 3 at this stage was not to apply now. It's not in the second schedule.
Let's go to this now the
54 order.
54 order. Let's
Yeah,
do that.
that's volume 3 again, page 13. That's it. 13 PDF. Yes. Yes. In exercise of the powers, you also have that? So exercise of the powers conferred by clause 1 of 370, President with the concurrence of the government of the state of Jammu is pleased to make the following order. The order may be called the Constitution Application to Jammu and Kashmir Order. So, Malad, supposing the entire constitution was to be made applicable, Malad, it would require concurrence, no? Only some are applicable, some are not yet applicable. You will see that 356 comes later. 356 doesn't come at this stage. That would also require concurrence, and concurrence was taken. So any provision of the Constitution of India which relates to the concurrent list would be made applicable subject to the concurrence of the state government. Consultation and concurrence, instrument of accession and concurrent list. And Article 1 and 3 are out of it. So kindly see, Malaj. Clause 2, the provisions of the Constitution which in addition to Article 1 and 370, in addition, shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply shall be as follows, the same pattern.
So the exception made here is the entire constitution is adopted subject to the modification
Yes.
made there. Unlike the
Other than 1 and
1950.
3, other than 1 and 3.
1 and 3 is already there.
That's right.
Unlike 1950 order, which had specific articles were made applicable. Now the entire constitution.
No, because 356 was not applicable at this.
No, but there would be a clause in this saying three
It's
fifty-six.
part by part, not true, Malas. Part by, see part 1, part 2, part 3. It's part by part. It's not all.
Is 356 specifically excluded
No, at this
in
stage.
this, at this stage?
Yes. Excluded.
It would be excluded at
After
this.
part 5, you have part 9.
Yes, come to page 15, 356 is excluded.
Yes.
So
at
the
this-
entire constitution was made applicable by the 1954 order,
Malas, it's said-
except to the extent of exclusion.
Malas, it's part 5 is state 11 straight away. There's no question of the entire constitution being included.
Just 1 minute.
Mr. Sibal, my learned brother may be, if with respect, right. I'll tell you another reason. I'll give you another, just apropos what fell from Brother Sanjeev Khanna. Just see now part 3. First, we'll just see one small provision, clause 2 of the order of 1954.
Correct.
Yes,
It says the provisions of the Constitution, which
yes.
in addition to Article 1 and Article 370 shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications shall be as follows. Now, one thing is very interesting. The word only which we found in the 1950 order has been deleted in the 1954
Right,
order.
Right,
So only goes.
yes.
Now, let's go to part 3 for a moment, and just to test the hypothesis.
We'll just go to part, yes.
Now, just see clause C in
Yes,
part
clause-
3.
Clause, yes, I
Right?
got it, Malas.
It says in clause 3 of Article 16, the reference to the state shall be construed as not including a reference to the state of Jammu and Kashmir.
Correct,
Now, if we see Article 16(3) of the Constitution,
yes.
it says nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government or any local authority within a state or any requirement as to residence within that state or union territory prior to such employment or appointment.
Right,
Now, if the entirety of clause 16 were not to apply to Jammu and Kashmir,
yes.
what is the reason for saying that only clause 16(3) will apply subject to these modifications?
For the simple reason that Malas, other clauses in respect of clause 3 of the constitution came into the J&K constitution later. And I'll show that to your lordship.
But is it your contention therefore that
Entirety of 16
that
applied.
16(1) didn't apply to the Jammu and Kashmir?
It did apply, it applied.
The part which is mentioned.
But how did it apply then?
No, part 3 applies in full. When it says part, your lordship may see they have a serial number and then they have A, B, C below each of these parts. So when they mention the part applies in full. Now, in that part, A, B, C will tell you the exception or modification of the provisions of the Constitution in that part. So when the part is indicated, the part applies in full. In the 1950 order, it was column. So in the second
That's what I was
schedule-
saying. See, in the earlier, the manner of printing of the two notifications
Yes,
is slightly
Yes, that's
different.
all, that's
That's
all.
very good.
In the first one,
Has been
there is a
expressly
column,
excluded.
Yeah.
it is an article,
Yes,
then what is the exception sort of
correct,
carved
correct.
out?
And the modifications, now it's.
Modification exception carved out.
So now
In
it's.
this, the way it is printed as I see it,
Yes.
when they say part 3, it means part 3 applies, but.
But these exceptions and modifications.
Column of modifications which were there
Yeah,
are specified underneath it.
that's
Exactly.
exactly
That's
what, it's
exactly-
nothing, no difference.
Other than what has been explicitly excluded.
Yeah.
The rest of the part 3 applies.
That's correct, that's all that there is. That's all.
Mr. Sibal,
Like
I
16,
think,
1 and 2 apply.
Mr. Sibal, just come to page number, internal page number, the first page, page 10 of the
Page
notification.
10, okay,
The provisions of the Constitution.
yes.
This means the entire provisions of the Constitution.
Page 10, your lordship's PDF page 10?
Yes,
Yes,
that's a notification, 14th May 1954, 2, clause 2. The
page
provisions.
13, not 10.
13 of the.
Or page 13,
Yes,
yes,
13,
yes, page
yeah.
13, you're right. The provisions of the Constitution,
Yes. Yeah,
which in addition to Article 1 and 317, Article 317,
Yes.
because that's covered by
yes,
3.
yes,
Now, the provisions of the Constitution refers to the entire provisions of the Constitution.
correct. Yes,
Shall apply in relation to the state of Jammu and Kashmir, full stop.
yes. Which,
Second,
the word
second,
also left the word out, which.
yes, I'm aware of that. That second part says, the exceptions and modifications subject to which they shall also apply shall be as follows.
Correct.
So thereafter, the exceptions are carved out
Yes.
with regard to each part of the provision of the constitution, which are either not to be applicable or applicable with modification.
Correct, correct.
And if you go down, it specifically says 356 is excluded.
Yeah.
In case this was specific inclusion, they need not have specified 356 is excluded. Because by implication, 356, if not mentioned in the schedule, would have been excluded.
But with the greatest respect, when you say kindly read it, just see. Kindly see part 18.
The very fact that some articles have been
Kindly see
excluded,
page 18. Kindly see page 18. PDF page 18.
yes,
Which is this. See part 18. 352, the following new clause shall be added. Above that,
correct,
part 18.
correct.
And therefore there are exceptions.
We are then at item.
But the part applies, but there are exceptions and modifications.
So
that-
part 18 applies, for example, part 18 applies,
Yes.
the modification is specified below that.
Yeah.
Then small clause B, 13, part 3, small b.
Therefore, there is no dispute on
The
that.
entire constitution has been
356,
applied.
357.
Except what
Exactly.
So these three articles of part,
Which shall apply shall be as follows.
Will not agree. That's correct.
Kindly see, and also it says the provisions which shall apply shall be as follows. Which shall apply? They are enumerating the provisions,
Then
that's all, Madam.
the next after that is what are the modifications?
Yes,
Or what is omitted. So
that's right.
mostly the modifications, but some are omissions.
Yeah.
For example, in part 19, if you see,
Yes, I have it.
Article 362 and 365 are omitted.
Omitted, yes.
366 clause 21 will be omitted.
Omitted, correct.
Otherwise, the whole of part
Will apply.
19, other than this will apply.
That's right.
The approach is instead of going provision by provision and enumerating 395, they went part by part. And they said this whole part applies subject to.
But
But
ultimately.
what about those parts which are not specified as parts?
They don't apply.
They don't apply.
No, that is a problem.
That's-
I'm not sure you're right on that.
You may not be right on that.
We have, in fact, in volume 1, we have the Constitution of India as applicable to Jammu and Kashmir, which shows that this is how it was.
Part 4 won't apply.
No, not at this stage. Not at this stage. Part 3 did not apply till 1954. Preamble did not apply till 1954. That's exactly the way they proceeded.
Well, that's the only.
And this is significant.
I think 15.
PDF 15. no? The part your lordships are referring to is?
If everything applies.
Yes.
Why were they specifically?
Yes, so part 4A is omitted at that stage. 4A came later anyway, but part 4.
The one way to look at it is part 4 will absolutely apply, of course, but without any modification.
Well,
But
that
where-
with
where
respect,
there is
that's not the
modification, then we
understanding-
specify.
That's not the understanding of the government of India then. That's not the understanding of the state of Jammu and Kashmir then. That's not the understanding, Malad, of any authority. Then, Malad, now we are saying, no, that was all wrong. Actually, everything
We're not
applies.
saying, we're just
And they don't,
discussing.
and you don't need consent.
Mr. Sibal, as I see it,
Yes,
every order
Yes,
extended different parts of the constitution
that's right.
to Jammu and Kashmir. Now, if a particular provision is with modification, it says so. Now, it may be by provision wise,
Yes.
or it may be part wise,
Yes,
it may be by any method,
correct.
but it keeps on extending by the
Yes,
orders
yes.
which are passed.
Yes.
So first one was provision wise in a sense. This one is part wise because practically the whole part was to apply
Yes,
with certain modifications.
that's correct.
To the extent that it is not to be applied, it is excluded.
That's right. That's the only submission. That's the only, and in any case, Malad, 1 and 3 are, 1 and the 370 are excluded.
That is from because of the first notification, separate clause C was made.
That's correct.
Clause C was made for Article 1.
So, Malad, this argument then doesn't take us anywhere because we are dealing with 370. We are not dealing with any other part of the constitution. So we can, Malad, interpret the orders any which way you want, but it cannot touch 1 and 370.
The two major points to my mind are this. One is your submission that Article 370 has acquired a permanent feature of the Constitution.
Yeah.
That's the debatable issue.
Yes.
Which both sides will debate. Next is, suppose it is not permanency. Then what is the manner of abrogating articles?
That's right.
Is that procedure followed or not?
That's correct.
The only two issues as I
Correct,
see it
correct,
in the
correct.
whole
But I'll
issue.
hope and try and convince you that it is permanent. I will try and convince you. I know, Malad, your lordship says it's debatable and it is debatable. There's no doubt about
So
it.
both things are debatable means both sides will argue this
Yes,
point out.
it's really debatable. But I tell your lordships, Malad, why it is permanent. Malad, now, for the moment, Malad, because we have only dealt with the Constitution of India.
Debate will also be on the second point. I look at a debate whether
Of course.
the procedure has been followed or not followed. They will say we followed the manner of abrogation.
Absolutely.
You will say not.
Now, Malad, so far I've only referred to provisions of this Constitution. But Malad, your lordships will have to look at the Constitution of Jammu and Kashmir. Because that Constitution, Malad, was framed and cleared in 1957. So, Malad, Malad, Parliament could only exercise, if it takes over under 356, declares an emergency, it can only exercise the powers of the legislature. That's what Bomai has said, and I take your lordship, you can't do anything more than that, right? Now let's look at the provisions of the J&K Constitution, which will give you an idea as to why it's permanent. Yeah, Manoj, I'm sorry, my understanding is right. Before we go to that, let us kindly see the volume 1, PDF 132. What date is this?
You are wanting us to go to PDF 1 now.
PDF is the date.
Volume 1 page, Mr. Sibal.
Manoj, volume 1, page 131. 132, Manoj. Now, Manoj, kindly see, this is the Constitution of India as applicable to Jammu and Kashmir just before abrogation of 370. And you'll see
Sorry, Mr. Sibal, which page?
page PDF 132.
In the same volume?
Yes, volume 1. Volume 1, Manoj, not 3. One second. Now, Manoj, your lordships will see the table of contents at page 43 first.
Which page? You said 132, 43, which one?
Sorry, 43 first. Manoj, it's a table of contents are set out.
It will take a little longer to get to it.
Sorry, Manoj, sorry about that.
It's our fault, Manoj. We are prompting you.
Page 46 or
43, 40. But the contents, volume 1,
Yeah.
looks somewhat like this.
There's one
The
little
Constitution
improvement
of
which we have
India.
to make in our written submissions format. In fact, I'm just in the process of issuing a standard operating procedure for filing written submissions on all matters before CB, which is that the index should be hyperlinked. So that'll be much easier for all
Yes.
the lawyers and for us also. We go to the index and just click on the hyperlink there.
43 is what you are saying?
Yes,
Yeah.
the index.
46 is the index.
Yes. Now, kindly see, Manoj,
Index actually
see-
starts earlier. Index starts from page 43.
Yes, 43.
43.
No, 43. Your lordship has that?
Part 4 doesn't figure in it at all.
Yes. And there's no order omitting it.
This is which year?
This is just before 370 was abrogated.
It's taken from a book of 2016, but it's as it stood there.
Now you see here, Manoj, after part 6, you have part 11.
Part 6, what page is that, Mr.
Manoj,
Kapil?
part 6 is at page PDF 48. And the next is, yes. Part 11 is page 49. So nothing is excluded. No specific provision. Therefore, the order says provisions which shall apply shall be as follows. That's why, Mother, the 54 order says what it says. Provisions of the Constitution which shall apply.
So notwithstanding the deletion of the word only,
Yeah.
the word which seems to indicate that these are the
That's
parts, the
really-
provisions which will apply.
So that's Muller's really. Now, Muller's in this context, kindly look at the Constitution of Jammu and Kashmir as it was cleared in 1957, passed in 1957. And remember, Muller's. Yes. Right.
Publication or government publication?
It's not a government publication, Muller's, but this is not hopefully not in dispute, Muller.
But Mr. Sibal, you are right that the constitutional practice which was followed since the adaptation order